We have had a very wide-ranging discussion this morning. We have had a panel discussion which has introduced a lot of direct feed issues that perhaps have touched on the detail. Niamh Higgins talked about problems with the conciliation and arbitration procedure. Bernard Gogarty touched on a very similar issue. We had Donal Winters discussing the issues to do with design completeness and how that affects main contractors' performance, how the transfer of risk is unfair, particularly in relation to inadequate site investigation. He touched on the issue of delay thresholds and Clause 9 delay thresholds, while not specifically mentioned by Anthony Hussey as a moral, must approach that test. A bizarre provision in these contracts. And Donal finished up by saying that this just does not encourage teamwork. Tony Hussey dealt with how contracts can fall apart even in the private sector, thanks to Mr. McKay in England. And he touched on an extremely important issue, which is that we still don't know exactly what the Construction Act is going to look like. We have the bill and we have aspirations, but we don't know what the Act's going to look like, and so we don't yet know to what extent it's going to help fix these problems. Anthony O'Leary, from a specialist contractor point of view, touched on some of the real specifics. He was particularly concerned about payment, and we had much earlier on Paul Morell and co talking about the importance of those that live down in the bottom rung of the poo ladder, and how payment is what keeps them alive. And so payment provisions and the introduction of the construction bill must be of extreme importance to subcontractors, and I think it's important that's not lost. Anthony also touched on the issue of the black economy and the effect that has on us all, and the tremendous practical difficulties with below-cost tendering. A lot of this was echoed by what Jim Curley said, but particularly from his point of view, from an M&E point of view, the idea of early contractor involvement delivering real efficiencies is a nettle that needs to be grasped, something that is not appreciated in this jurisdiction at all. But it's somewhere that whenever you consider the very high proportion of contract value that's driven by M&E, has got to be important. Susan Bryson talked extensively about procurement, and a theme that has run through today has been the interrelationship between procurement and the contract issues. Particularly, she felt that the procurement system is broken, and I take from that it means it needs a major overhaul. Whenever we heard what Andrew Nugent said about the procurement system from a professional practice point of view, and I can speak from some experience having dealt with a large number of procurements, the procurement situation is dire. And in terms of delivering efficiency, it must be something to be looked at. Susan came up with some very practical suggestions about how an objective scorecard should be used. And bringing objectivity into the procurement system, I think, would be welcomed by everyone. Dudley Solon, practical as ever, touched on particular issues in the construction contracts that don't balance risk effectively. And took us to some of the detail, particularly the idea that oral instructions cannot be obeyed, which is utterly counterintuitive and completely counter to any sensible partnering arrangement and on-site arrangement. The need for notices, which also are frequently confrontational, or seen as confrontational, is now an institutional part of these contracts. It was identified by him. And the idea that a contractor can contract on the basis of zero costs for delay, and I think a particular point that Dudley brought out was that leaves no incentive for an employer to be mindful of delay. It cuts back the communication loop from the employer causing problems to him receiving the pain of those problems. And I think that's an important point. David O'Brien, who is in the happy place of being the chair of the Construction Contracts Committee, and I suspect is probably one of the most popular people in the room as a result, said a number of things from which we, I'm sure, can all take hope. He talked about reasonableness, and in order to deliver partnering, reasonableness must be part of the way forward. He did mention, and I think he's right, that in terms of management resourcing, the public works contracts here are just as management intensive as the modern construction contracts north of the border or across the water. The NEC and the modern JCT contracts require those resources. And that underlines the importance that those resources are delivered efficiently. It's an education thing. We are going to have to manage complex contractual situations. That's here to stay, whether it's the public works contracts or we go with one of the other modern contracts. So that's an education issue. He touched on the importance of tackling procurement. So he's alive to that clearly, and clearly that needs to be part of the process. And he looks forward, I'm sure, with great joy to working with us in resolving all of this. Bernard touched on some very important issues, which again I'll characterise as education. His concern, and it's echoed by many of us, is that because litigation has evaporated from the construction contracts here, there will be no way to have a proper interpretation of what difficult contractual clauses mean. I'm sure he wasn't encouraging us all to resolve everything in the commercial court for the joy of contractual full understanding, but certainly education in terms of what does the contract mean? What does it really mean when a set of circumstances happens in accordance with that clause of the contract is something that we would all welcome. We had two speakers from the employer side, Jonathan Bliss and Tim Ahern. Now, from my point of view, it's the employer side that matters most, and it is what Tim and Jonathan said that for my money, is the thing to which we should pay most attention. Neither of them were convinced that the public works contracts were unworkable. And in that respect, I don't see how they're wrong. Both of them were alive to changes that needed to happen. One of the points that Tim brought out, which is a procurement point, which I think is extremely important, is that efficiency does not need to be at odds with legality. Whenever Susan was talking about having an objective system for procurement, that must surely mean we can bring an efficient procurement system more comfortably within the law, and that would be a great thing. He mentioned, from an employer's point of view, the difficulty with suicide bids, with abnormally low tenders, and just what effect that has, and perhaps also what little effect it has on the outturn cost of the project ultimately. So dealing with abnormally low tenders and dealing with under-cost bidding is something that it's refreshing to hear from an employer side they're alive to. He also mentioned difficulties with dispute resolution. I was delighted to hear that engineers should have been in charge, slightly more concerned that if they touch the law, they become quasi-lawyers and therefore sink to the bottom. But I will rise over that. The issue with dispute resolution and how that balances risk in the operation of the contracts must be key. One of the consistent themes with the more recent amendments to public works contracts is that it silences the contractor rather than forces the employer to listen to the contractor problems. And the dispute resolution principle systems and the way that they're being operated it only serves to silence the contractor, and so does not allow an effective communication, does not allow effective partnering. Jonathan started with the courageous statement that he had no substantial issues with the new forms of contract. And he was absolutely right, in my view, to give us an equivalent of blaming the car for the car crash. It is all members of the industry that are travelling in the car, and all of us have some culpability in terms of the difficulties that the industry is in. But it is inappropriate to just blame it on the contract. Having said that, he was alive to the idea that there were improvements that could be made. Particularly, it was good to hear what I think is best practice in public procurement, which is the appropriate transfer of risk. So the Department of Education's view that risk should be appropriately transferred rather than ruthlessly transferred to contractors must be important. He said that while fully designed projects were impossible, the level of contract documentation should be improved. And that has to be right also. Where Donald Winters says that fully designed projects are what is required, I suspect that is the other side of the coin, which delivers zero defects at the end. Jonathan touched on the procurement process and finished up by saying that best practice was the way forward. How that can be disseminated, how that education process can be disseminated, I think perhaps something that could be more clearly understood by the public sector. But it is right that the contract documentation could be more correct and that contractors could be more diligent in their execution of the works. Two of the things that he finished up with. Andrew Nugent painted the picture from a professional practice point of view. He pointed out the considerable difficulties with public procurement. He also touched on the particular difficulties with a new contract, the rigidity of their execution, and how, as a professional practice person, presumably, he has little room to exercise discretion. He talks about full design not being reflected in reality, and that is a theme. The poor quality of contract documentation is clearly a theme. And he emphasised the need for education, professional education and client-side education. Our two representatives over from England, Steve Roswell, he emphasised the importance of collaborative working and how collaborative working can operate. He talked about how poor risk understanding and risk transfer poisons partnering and leads to tremendous inefficiencies. But he did point out that what the client needs, and the client needs price and time certainty and best value for money. So we can't escape from the need to deliver that as an industry. Paul Morell produced a presentation with more slides than I thought existed. Absolutely brilliant. The Tower of Babel, stop arguing, get on with building. The need for education, the idea that in England they have a project managers academy for senior civil servants with a view to that only those that go through that process being allowed to run large capital projects sounds absolutely fascinating. He also touched on the value of the work done at the drawing board, the need for the accuracy of design and how that influences the outturn costs and the entire industry, so the importance of design early. However, a big theme from Paul and from those that preceded him is the huge problem that the industry faces going forward. He touched on the need for us to address our energy spend. He touched on the need for us to deal with the costs of the industry and how dramatically different the industry needs to be if it's going to succeed in those terms. He showed us a picture of work in China, and I suspect that if the Irish construction industry can't deliver, it won't be very long before the Chinese construction industry will be quite happy to come here and deliver for our public sector clients. So there are challenges which don't exist today, but in 10 or 15 years' time are highly likely to be alive. And that's something that perhaps we need to keep in focus. we had Minister Rabbit saying things that I suppose underline the importance of our position. He said that this is an important initiative. What we are doing is an important initiative. He talked about the constraints on him, the constraints on funding, and the constraints on hitting the energy targets, which are going to be a requirement for us. He talked about the skills needed for it, so the education needed in delivering the future construction industry in Ireland, and that the construction industry is interested to see how it works. Whenever Philip Crampton kicked off this morning, he talked about this review being a 360-degree review, including clients, consultants, contractors, and lawyers, those of us that work in dispute resolution, and that all of us have a part to play in delivering success. He talked about public sector procurement being a core requirement for the construction industry. I think the mirror image of that is that the construction industry is a core requirement for the public in Ireland also. So partnering works on a very big level as well as on a minor one. So there you are. Those are my themes that I have taken from today. There's partnering, there's difficulties with procurement, particularly lowest cost, and the implications of EU procurement law. There's the need for education, both among ourselves, among consultants, and among clients, and how the risk of poor education is distributed. And then there's the detail of the contract. There's what we are actually going to do about the requirements for the notices, the requirements for contingencies, the requirements for risk transfer and dispute resolution. And I'm very glad that I did not have Don sitting here banging a hammer. Thank you very much.